Welcome to the webinar series through Stockland Retirement Villages. Today's session is on the importance of estate planning and making a will. I'm Les Mace. I'm a director at New Way to Stay. We're hosting 4 webinars through the Get Online Week for Stockland. A very special guest and expert today is Keisha Gamble, and Keisha is the head of wills and estate planning for Coots, lawyers and conveyancers, and I'll introduce Keisha a little bit later on, a bit more detail. Just a little bit of housekeeping. You are all unmuted. You can ask questions on the way through. So we only have half an hour. You can ask questions on the way through. You can save the questions to the end when we have a little bit of time. That's entirely up to you. You are unmuted, but you can mute yourself if you wish, and you all obviously know how to do that. You can also ask questions using the chat facility on the bottom of the screen. We will have questions and chat time at the end. I can see everybody, so if you want to put your hand up and say, I've got a question, then by all means do that, or just speak up, whichever is you prefer. So you can put your hand up virtually or actually. And then there's a follow-up and feedback session at the end. So just a little bit about New Way to Stay. Perhaps the interstate people may not have heard very much about us. We're Stockland Benefits Plus partners. We have been since late last year. Earlier this year, we did a speaking tour, if you like, around the villages in Sydney and some in regional New South Wales. Our intention was always to go more broadly than that and to come to Victoria, Queensland, South Australia, etc. But the dear old COVID got in the way, so we were locked out, obviously, like everybody else. But hopefully we will be able to pick those up again when things ease, and who knows when that'll be, but hopefully not too far down the track. But New Way to Stay, we're advocates and planners for later life. We help people to keep and take control of their life. As I said, we're advocates and planners. We cover a myriad of options for people. We look at their health, we look at their mental state, financial services. We look at their legal situation, home safety, the well-being, home care, government benefits, and whether they live in retirement villages, nursing homes, want to stay at home, home care, etc. All the things that people need assistance with as they age. So just roughly, quickly, how we operate is that we work one-on-one with our clients, and we have a number of Stockland residents as clients. We briefly discuss their needs over the phone. Once we have understood what it is that how we may be able to help a client, we then agree to meet for a review of their goals and concerns. That's always been face-to-face, and it's our intention to be face-to-face, but through COVID, obviously, we've done most of that work on Zoom. And that'll be a client's choice in the future, whether or not they want face-to-face or concern. We love to go to people's homes, because if it's people who are preparing for their aging journey or are in that situation, then we like to have a look at the house, because part of the thing we look at is safety and those sorts of issues. But we help the client determine what their goals are. Then we go away and we create a plan to help the person achieve those goals. So whether those goals are purely in health, it's an overall whole of life type arrangement. So for argument's sake, we will look at their health situation. We'll look at whether they have a home care package, whether they need a home care package, whether they might qualify. We'll help them with their financial assessments should they need help there. We'll bring in people like Keisha and Coots if they need to have their will and estate plan done, etc. So we create a plan, a very detailed plan, and then we report that back to the clients. The client can then take that plan and implement it themselves. or they can we can work with them, or they can work with us for us to implement that plan. So that's just a very brief snapshot. There's another session on Friday where we go into it in much more detail. But more important than that, I'd like to introduce you to Keisha. Keisha's a senior lawyer at Cootes. She heads the wills and estate planning team. She's been a successful and established lawyer in the Macarthur-Camden region in the greater southwest area of Sydney for in excess of 5 years, and has extensive knowledge in estate planning and estate administration matters. Keisha runs that part of the business and has a team of people that work for her dedicated to wills and estate planning. She's a dedicated professional, assisting her clients through estate planning and administration processes, and ensures that their affairs are dealt with in an empathetic and comprehensive manner, and prepares and drafts individual documents that accommodate all of her clients' concerns, needs and wishes. So very, very lucky this morning to have Keisha with us. So thank you for your time, Keisha, and I'll hand over to you if I can work out how to do that.
All right. I just wanted to say a big welcome and thank you for Stockland's residents for jumping online today. It's a great initiative and I'm certainly very excited to be a part of it. And a big thank you to Les from New Way to Stay for inviting me to give this presentation. I've just shared my screen there, so it would be wonderful if you could let me know that you can see the presentation. Yep. Okay. Wonderful. So today I'm going to be talking about all things estate planning, including what makes a valid will, the pitfalls of a do-it-yourself will kit, what happens if you pass away without a will. I'm going to illustrate all of that with the Peter Brock story, which you may or may not be familiar with already. And I'll finish with an overview of what documents you need to protect your estate, and we'll probably have some time for Q&A at the end. So did you know that 45% of Australians do not have a valid will? But a will is one of the most significant legal documents you'll sign in your life, and it's important to get it right. Having a valid will allows somebody to meet two goals. It allows them to have their wishes upheld, primarily, and makes things easier for their family when they pass away. If your will isn't written properly, it's possible that neither of those goals will be met. For a will to be valid, it needs to be in writing. It needs to be signed by the person making the will in the presence of two independent witnesses. And those witnesses also need to sign the will. And lots of people say to me, but do I really need a will? And the short answer I always give them is, if you want to make sure that your assets pass to the people who you intend them to pass to, then yes, you do need a will. And then the next question I get is, well, can't I just do that one from the post office? And I always say, look, DIY wills, do-it-yourself wills, grabbing a piece of paper, scribbling something down is always going to be better than no will. But it's certainly not without its pitfalls. And the biggest problem with do-it-yourself will kits is that it's so easy to get them wrong. The simplest of mistakes can make the will become contested or even held to be invalid. And some of the most common problems that I see when somebody passes away and I get given the will and it's a do-it-yourself version is that it attempts to give away assets that the person didn't own. It might try and give away assets that they held jointly with someone else, and it might try to give away superannuation or life insurance, which are controlled entirely by another mechanism. Sometimes the will is too specific. It's gone through and listed the person's assets individually. My house, my car, my bank account, my shares, my pet cat, and it doesn't have a catch-all clause. And the problem is, without that catch-all clause, there could be assets that you've forgotten about that are undistributed now, okay? Sometimes the handwriting is simply just too illegible to read. If no one can read your will, then you can't be certain that your wishes will be upheld. And lastly, of course, it fails to comply with the basic legal formalities for a valid will. They're often seen as the cheaper option to seeking legal advice, but I think I would demonstrate that that's not necessarily true. In all of the time I have been a lawyer here at Coots, I have only had one do-it-yourself will that hasn't caused a problem for the family. All the rest have had one or more issues that I've mentioned before, and while some mistakes are small, not all mistakes can be fixed. The next thing I'd like to talk about is what happens when somebody passes away without a valid will. Well, it changes from state to state, but it's all very, very similar in that that person is said to have died intestate. And what that means is that the assets in their estate will pass to a class of beneficiaries that has been predetermined by law. So it's an order, like a hierarchy, that's been determined by each court in each state to achieve a blanket solution to what that person might have done with their estate if they made a will. And just for the illustrative purposes, I've put the New South Wales order up there. So if someone passed away without a will in New South Wales and they left a spouse, their spouse would take their estate. If they did not have a spouse who was living, it would go to their children. And what you need to do is actually move through each category before you can move down to the next. So no spouse, no children, it will go to their parents. No spouse, no children, no parents, it would go to their siblings. And you can see how that order would eventually move through lineal descendants of the family, right down to cousins. And lastly, if there was no living relative around, the New South Wales government. The furthest I have got in an administration matter where someone passed away without a will is right down there to cousins. But the difficulty with establishing that all of those other people had passed away with birth and death certificate evidence was going to be far too onerous of a job for my clients to even begin the process, which was a bit regrettable. As you can see, the order is not perfect, and it might not be what the person wanted to achieve had they actually done their will. The situation only gets much more complicated with blended families, because that predetermined formula doesn't really work when you have second marriages, biological children, stepchildren, and all the rest of those things that come with a modern Australian family now. And I thought the best way to illustrate this for you and the importance of having a will in place was by telling you a famous case study. Peter Brock was an Australian racing legend who left things a little too late to advise his family of his last wishes. He had 3 wills throughout his lifetime, and all 3 attempted to achieve something very different. We're going to go through them now. So in 1984, Peter Brock prepared a formal will with his solicitor. In this will, he gave some monetary gifts to family members, all of his furniture and personal effects to his spouse, Beverly Brock. They weren't married at the time, but she did take his last name. He gave a right of residency to Beverly, which means that she was allowed to live in the home until their youngest child turned 18. And then he gave everything else to his 3 children. Robert and Alexandra were his biological children, and James was his stepson, son of Beverly, who he raised as his own. In 2003, Peter sought to update his will and got himself a do-it-yourself will kit from the post office. In this will, he completed the sections which appointed new executors, and he popped in his funeral wishes. Pardon me. He did not fill in the section in the middle about what was going to happen with all of his assets, when he passed away. Instead, he said to Beverly, "You just fill this in with what you want to happen when I pass away." He signed the will in the presence of his personal assistant and Beverly. The personal assistant completed the witness section, but Beverly didn't. Beverly never filled in the details in the middle, and it was stored away in the safe. In 2006, Peter Brock had separated from Beverly Brock the year prior and was in a secret de facto relationship with Julie Bamford. He brought another do-it-yourself will kit into the office, and he asked his new personal assistant to write it up while he dictated to her. In this will, he wanted to leave all of the money in his bank accounts to Julie, his superannuation account to his children, all three of them, and all of his racing memorabilia to the Peter Brock Foundation. Peter's personal assistant said to him, "I've got some concerns, Peter, that this is pretty complex and I think you should go and see a lawyer." They put the DIY will into the cabinet. It wasn't signed by Peter and it wasn't witnessed. So when Peter passed away from the unforeseen car accident later in 2006, the whole matter went to court to determine which will was valid. The court found that the latest will he did in 2006 was invalid. It wasn't signed, it wasn't completed, it wasn't witnessed. The second will in 2003 also wasn't completed, but it was signed and it was witnessed. And the first will in 1984 was automatically revoked by the first clause in the 2003 do-it-yourself will kit, which is pre-printed to say, "I revoke all former wills." So the second will made in 2003 was held to be Peter's last will. But all this will did was revoke the earlier will. It appointed some executors and gave some funeral wishes, but it didn't actually deal with his assets. Remember, he left it blank. So the executors had to distribute the estate in accordance with the rules of intestacy and that order that we talked about earlier before. Remember, it was spouse, children, grandchildren, so on. He'd been separated from Beverly, and that was very public, but his relationship with Julie Bamford wasn't known. So the hierarchy was for his estate to be distributed between his two adult children, Robert and Alexandra, but not his stepson, James, who we know throughout his life he raised as his own and wanted to benefit. And so that outcome is very different to what Peter had dictated to his personal assistant in 2006. Of course, Julie Bamford went on to contest the will, and we know from the media that the estate privately settled her claim outside of court. So we don't actually know for how much, but it did get resolved privately. But what I'm trying to illustrate here is that do-it-yourself wills are seen as a cheaper option to seeking legal advice, but it runs the risk that it would be considered invalid if you've overlooked something or it hasn't been signed properly. And of course, for the multi-million-dollar estate that was owned by Peter Brock, comments made by Beverly Brock to the media was that there was next to nothing left after 3 years of fighting in court. I've got a few minutes left before some questions, so I thought I'd just also like to illustrate that estate planning isn't just about making a will. It involves thinking about setting up documents for someone else to help you with your decision making whilst you are alive, but in case you do not have the mental capacity to make decisions for yourself anymore. And you've probably heard about these documents before with terms like power of attorney, enduring guardian, advanced care directive. And it's important to remember that each state and territory in Australia has their own laws and their own version of the document that you would need to give someone else decision-making power for you. So I've prepared the table on the slide there just to show the different documents for each state. But really, they all have the same function. It's for you to be able to nominate someone else who you trust to make legal, financial, property, and medical decisions on your behalf if there was a time where you couldn't do it for yourself anymore. And the law is the same across all of the states. If you passed away, the person that you nominate in these documents isn't authorised to act anymore, and that's where your will comes into play and your executor then takes over. One thing that is common throughout Australia is that you want to make sure you're picking the right person for the job. So I thought I'd leave you with some tips about what you should consider when you are choosing someone to make really important life decisions for you. So obviously you want to consider the age of the person. In every state and territory, the person you nominate needs to be over the age of 18. But in my experience, probably more so in their late 20s, early 30s at a minimum. Just so there's that little bit more responsibility and life experience, I say. The location. Where do they live? Are they close by to actually help you out and sign documents and make decisions on your behalf? Are they someone who you trust to look after your best interests? Or do they have their own agenda? Or are they easily influenced by others? This is really an important one because there might not be anybody watching the decisions that they make, and you want to make sure that the person you pick has values that align with yours and really understands what it is that you want for yourself. Do they have the mental capability of making financial decisions, or at the very least, if they're a bit out of their depth, do they know where to go for help? I.e., will they go see your financial planner? Will they go and get advice from places like Les at New Way to Stay about what would be the best plan for you? And if you're going to choose more than one person, which is allowed, do they get along? Are they able to cooperate with one another? And lastly, I'll just finish off with, when is it the right time to start looking at your estate plan? Well, if you're making a new will, it would be a good time if you buy a house or inherit assets of your own, if you are married or in a new de facto relationship, if you have children or adopt children, or if you become separated or divorced. If you already have a will, then you should frequently update your will or review it, and update it if your assets substantially change, if your children are now adults and have children of their own, your grandchildren that you would want to benefit, if somebody who you've named as a beneficiary or an executor has passed away, or something that they've done which means they're no longer suitable for that role. And really, the last one is if you have a change of mind.